Back in 2004, when everybody watching this was very, very young, Donald Trump had a television show, and it was quite successful at the time. It was called The Apprentice. It was made by the same guy who made Survivor, who still makes Survivor. And on The Apprentice, at the end of every episode, he would fire someone. And except for the very last episode where he would hire someone. But anyway, he would fire someone, and his last words at the end of the episode would be, "You're fired," to whoever it was he would arbitrarily and capriciously fire. And back in 2004, when his show was very big, he tried to get this trademarked. You might have heard that he had a copyright on this catchphrase. There was kind of this idea circulating on the internet for a long time that he had a copyright on "You're fired." That's impossible. And you can probably guess, based on what you've heard so far, why it would be impossible for him to copyright this. And that's that there's specifically built into the American legislation on intellectual property an impossibility for copyrighting very, very short catchphrases. So "You're fired" would be too short to allow for any copyright at all. Now, I mentioned that Donald Trump tried to get some intellectual property in this phrase. He didn't even try to get it copyrighted. That's just kind of how the internet interpreted it. What he tried to do was to get a trademark for it. And if we think back to what the difference between those is, it's not that he's trying to protect the ability of anyone to, print up a pamphlet that says "You're fired" on it and be able to sue them for it. It's that he didn't want anyone to be able to use the phrase "You're fired" commercially without paying him something, right? If his logic would have been that if somebody puts out something that says "You're fired" on it, then they're trying to gain some credibility or some association from him. However, when he applied to the Trademark and Patent Office in the United States for a trademark on "You're fired," they refused him back in 2004. The next case is a little bit different. This was a case that actually went to court in 2002. So what happened is Lego, which I'm sure everyone's familiar with Lego. Lego had built this amazing interlocking block system, and they had managed to get a patent on it for this toy system. And the patent in Canada was registered in 1969, I believe. I might be off by a couple of years there, but they registered the patent whenever they did, and the patent was on the mechanism, really the design by which these blocks would lock together and snap together and make these toys that would stay together, even though you weren't gluing them or anything like that, right? And they were obviously very intent on being able to maintain their exclusivity as the only ones able to make this kind of thing. But the problem was that their patent was expiring in 1989. And once the patent did expire, a whole bunch of other toy companies decided to essentially rip off the design of Lego and make these interlocking block toy sets. Mega Bloks was one of them. It wasn't the only one. Like Duplo was out there as well, but Mega Bloks was making these essentially Lego block toys that were bigger, and they were selling them. And obviously, Lego was saying, this is not very nice. They're essentially just borrowing our idea and making a whole lot of money off it. And so they wanted to sue Mega Bloks. Problem is, if your patent is expired, you can't sue somebody else for infringing on your patent, right? Patent allows you to be the only one to make that thing. But if that patent runs out, then anybody else can make it. You can't complain about it anymore. So Lego had to come up with an idea. And in 2002, when Mega Bloks was essentially ripping their market share apart, Lego decided, well, we're going to sue them not on the basis that they've infringed our patent. We're going to try and convince the Canadian federal court that the blocks aren't just protected by patent, but that their distinctive appearance immediately makes people assume that they're made by Lego. So that when Mega Bloks is making these interlocking blocks, people assume when they're buying them that they're buying a Lego product. And if a reasonably informed member of the public could reasonably confuse one product for the product made by another person, they figured, look, that's trademark infringement. That was their argument. The Canadian federal court didn't buy it. They dismissed the case. They said, sorry, you got a patent because you knew that patent was the way to protect this thing. You knew this wasn't a trademark thing. Mega Bloks isn't writing the words Lego on their blocks. They're calling it Mega Bloks, and people are just as happy to buy it even though it's not made by you. So we can't give you this trademark protection. And you can see why Lego would want trademark protection, because even though the patent would expire in 1989, remember, trademark protection lasts forever. So Lego was not only hoping to nail Mega Bloks in 2002, they were hoping to nail any other prospective toy maker for the rest of all time who might try and build something that looked like Lego. And the Canadian federal court stepped in and said, no, I'm afraid your time is up. You're going to have to come up with something new. Which is why, if you look at the kinds of products that Lego makes now, you don't see them making things that are so much interlocking blocks, because they don't make a whole lot of money off that. And everybody else can sell it cheaper. They put together stuff that's more character-based and more story-based now. But anyway, there's a long history of Lego. It's fascinating. You can look it up. The next case I want to look at with you is, again, this is probably long before your time, thankfully for you. Back in 2008, there's this person who was, again, connected with reality television. Her name was Paris Hilton. She's an old lady now, and you probably don't even know who she is. But anyway, she was very famous for about 10 or 12 minutes back in 2008. And one of the things she was famous for was saying, "That's hot." That was kind of her thing. She would say, "That's hot." You see, this is very, very thrilling for people at the time. It was a different time. I mean, I guess we had the internet, but apparently we didn't know how to use it if we found this entertaining. But she would say things like, "That's hot." And it was a phrase that was associated with her. Now, what happened was Hallmark Cards came out with what they thought was a funny little greeting card that was meant to show a waitress's Paris Hilton's first day at work. And she was bringing some food to some people, apparently, in this greeting card. I've never actually seen it. And she's saying as a waitress, "That's hot," in reference to the food. So it wasn't particularly funny. But this was what the court case was over. And what she did was she sued Hallmark Cards, said, "Look, that catchphrase is so associated with me that I should have a trademark over it. And you shouldn't be able to just use it without paying me some endorsement money, because everybody's going to assume that I'm endorsing your stupid card because you're using my catchphrase on it." So Hallmark tried to get the case thrown out of court. They didn't succeed. And now the case was still ongoing. Both sides decided the best thing to do was to settle for it for an undisclosed amount of money. We don't know how much. But essentially, Hallmark lost. They were trying to actually get their card protected by freedom of speech, indicating it was transformative speech. They didn't succeed. All that to say, even though it was only 2 words, she was able to get a trademark on it. It's more distinctive than Donald Trump's "You're fired." So "That's hot" apparently was distinctive enough.